I hope everyone has had a wonderful start to their 2025. Welcome to our panel discussion today, Nations on Trial, Examining State Responsibility in National Justice, presented by the American Bar Association's International Law Section's International Criminal Law Committee. My name is Denise Tamer, and I'm honored to serve as your moderator for the next hour. As a 10,000-foot overview, or I believe that's 30,480 meters for those so inclined. State responsibility is the basic idea that states, as an entity, can be held liable for or held accountable for crimes committed. For example, in courts like the International Court of Justice, a state is held liable for violating their treaty obligations. Notably, in 2001, the International Law Commission produced Responsibility of States for Internationally Wrongful Acts, a document that, while never formalized into a convention or treaty, continues to influence judgments from international tribunals, including the ICJ. This form of justice seeking is different than from what happens at, say, the International Criminal Court, where an individual is held responsible for committing a crime. The Nuremberg trials, the International Criminal Tribunal for the former Yugoslavia, and the International Criminal Tribunal for Rwanda are all famous examples of trials where individuals were held accountable for crimes such as genocide or other war crimes. So, which is better? Which is more effective? Is there space and need for both methods? Will 2025 be the year of state responsibility? Today, we have 1 hour and 2 panelists to tackle these questions. Nerissa Kashfi Rasumdar is a principal lecturer at Canterbury Christ Church University in Kent, England. She is a member of the Trinidad and Tobago Bar since 1999. She has been researching and teaching in international and criminal law for over a decade and has also worked as a state prosecutor for 10 years in Trinidad and Tobago, where she prosecuted a variety of offenses, including murder, sexual offenses, and narcotic trafficking. She worked as a visiting professor in the pretrial chambers of the International Criminal Court from October 2020 to April 2021. Her research examines accountability for international crimes through multiple lenses. Sean Fleming is a research fellow in politics and international relations at the University of Nottingham. He is the author of Levanthian on a Leash, A Theory of State Responsibility. He has published articles and chapters on many related topics, including treaty obligations, state crimes, theories of agency and personhood, and the political thought of Thomas Hobbes. Dr. Fleming is also a leading expert on anti-technology extremism. His next book, which is quite a different turn from his previous one, Darwin Against the Machines, How the Unabomber Turned Science Against Technology, will be published by Cornell University Press in 2026. I am very, very grateful for both Nerissa and Sean for being here today. Our format for this discussion will be conversational, organized around questions that I will present to both of them. For those of you in the audience, if you have a question, please go ahead and drop it either in the chat or the Q&A box. And my hope is that I will weave it in as we're going along, or that we'll have time at the end for me to ask any remaining questions. And so that's the stage. And let me start with you, Nerissa. Nerissa, what is the goal of state responsibility?
Well, thanks so much, Denise, and thanks to the American Bar Association for inviting me. Now, I'm going to talk in different levels. So I'm going to start with level 1. To me, state responsibility is the legal process that allows for reparation of international wrongs. Now, that will lead me to the next thing. You may say, well, Nerissa, what's an international wrong? Well, according to the articles on state responsibility, which is not a treaty, but it's a very good starting point, and it makes sense, an international wrong is a breach of an international obligation. Now, all legal systems, domestic and international, are premised upon, as Sean will probably pick up later, is premised on order, and we create systems based on our own different codes and approaches to establish that order. And part of establishing that order is to create obligations. So international law is very much about understanding the obligations that are on states, primarily states. And the system of state responsibility is a unique system that allows us to address two things. One, has there been a breach of an obligation? Has a state failed to do something it said it would do, or did it do something that it should not have done? And those are the primary obligations that are upon a state. But state responsibility as a legal system is an animal unto its own. And the reason why I say it's an animal unto its own, let's leave the primary obligations to the side. Once we've established that there has been a breach of an obligation, the goal of state responsibility is to work out who is responsible for that attribution. Is the state responsible? Is the state responsible to the point that it must now reparate for that wrong? And when I say reparate, make good that wrong. And this is the beauty of this discipline. And this is perhaps why I left criminal law and decided to pursue international law. So if you could bear with me, ladies and gentlemen, let me go into this into a little bit more detail. A state is a juridical fiction. It's an abstract entity. Like a corporation, like any other entity that has legal personality, it is comprised of individuals, but as a matter of law, we as individuals have created it into a separate entity for itself. So the process of state responsibility, the goal of state responsibility is to examine the extent to which acts of individuals can be attributed or imposed upon a state so that that state now bears, well, I'll use the word we use in international criminal law. In criminal law, it now bears the culpa, even though that doesn't exist as a matter of philosophy or reasoning in state responsibility. It's an individual concept. But the process of state responsibility is to determine the point at which now the activities of particular individuals can be attributed to the state. And the consequence of that now is that the state must make good for that breach of an obligation. And reparation is deep as it is wide. There are many things you can ask for in reparation that can really strike at the heart of international criminal justice, in that you can ask for cessation, you can ask for orders of non-repetition, you can ask for provisional measures, as we are seeing right now playing out before the International Court of Justice before our very own eyes. So to say what is the goal of state responsibility, from my personal perspective, I would say the goal of state responsibility is to create that system for reparation of international wrongs, but it goes deeper. It is to go back to those basic things we promised when we started to have this institutional approach towards a regulation of international law, and that is to make things better so that people who offend can be called out. The state can then take systemic action to make good. Now, I know there are several students in the audience here, and there may be an important distinction that I would like to make at this stage for the younger ones. There's a distinction between state responsibility and individual responsibility. State responsibility are matters that will involve state actors, and you deal with the jurisdiction of the International Court of Justice. Individual criminal responsibility is the responsibility an individual bears for participating or committing an international crime. And that is a different regime of responsibility. And right now, the world court that we have that deals with most of them is the International Criminal Court. But you would have seen tribunals like the International Criminal Tribunal of Yugoslavia, of Rwanda, and so on, dealing with those things. And even under the principles of universal jurisdiction, domestic courts can also deal with international crimes. These are parallel, independent tracks of responsibility that mutually support each other. So when we are looking at things like, let's say, for example, an international crime, it's big, it's complex, it operates at a systemic level. So we may attack it on one perspective, from the individual perspective, by putting that individual before court. But we can also look towards deeper forms of prevention and suppression, perhaps through state responsibility, in that you can look for reparation that can deal with the crime before it has happened. Individual criminal responsibility focuses on prosecution and sanction. To me, the state responsibility regime And that ability to reparate for international wrongs, it starts even from the minute that wrong has happened. So it's not so much an end game, but it allows the law the tools to start to address responsibility for international wrongs, even at the start of the wrong, so you can intervene and take greater roles in prevention. Both have their own roles, but I think this will be the goal of state responsibility. Get it before it happens, or prevent it before it goes further, or stop it and ask for them never to do it again. These are the noble goals, but we'll talk more about how it really pans out later.
Sean, let me give you the opportunity to respond. Thank you for that introduction, Narissa.
Well, thank you, Narissa. I think you've amply covered the question of what the goal of state responsibility is. So let me just say a few words about the additional question of what the goal of state responsibility should be. And I think this is somewhat contested. So on one side, there are those who think state responsibility should remain purely reparative, that it should be about cessation and satisfaction and restitution. But on the other side, there are those who argue that state responsibility should be punitive as well as reparative. If there are corporate crimes in domestic legal systems, then maybe there ought to be state crimes under international law. And if this is the case, then state responsibility could serve additional goals, such as retribution or deterrence. So there's an outstanding question of whether state responsibility should really be about compensation or whether it should go further than that, whether states should really be put on trial.
Well, that is an interesting thing. And well, I would probably like to go back to the debates before the International Law Commission before 2001. And I'm taken back to the words of Bruno Simmer when he was talking about that excised Article 19 on state crimes. It was heavily debated by states whether they should introduce that concept of state crimes or punitive measures into the articles and into the approach. And I was always struck by his words when he said, "But we drove that incubus out of the articles. We exercised it." And there were a lot of complexities in that notion of state crimes. So, how the International Law Commission sought to address that is by changing the nomenclature so that we suit the nature of the regime, and that is by dealing with it as a grievous breach. So something like when you say should be punitive, reparation is deep and wide in that it can take the form of punitive, in that an order can be made that these people be remitted for trial, as happened in Bosnia and Serbia, where requests were made for the surrender of fugitives to stand trial before the ICTY. So it does, like I was saying before, it does work in connection. And the reparation, it may not necessarily rest only upon questions of compensation, but there is that potency to address that punitive aspect without, because it is its own unique thing, and because there would have been logistical differences with calling out a state as a criminal, because the notion of criminal responsibility philosophically it is very much an individual responsibility, whereas this regime moves in terms of obligations. But if we were to cut all those academic distinctions aside and really look at what it's doing, it can do that. It can do that. They may have excised the term state crimes, they may have cut out Article 19 from the final draft articles, but at the end of the day, that power is there. Because in Bosnia and Serbia in 2007, history was made. The court held, the International Court of Justice said, a state can be responsible for genocide. However, for that state to be responsible for genocide, we'll have to make sure that the activities of the individuals could be attributed to the state, so that we had to examine whether it was de jure or de facto organs. And that's where another of the complexities start to emerge. But I do agree with you, Sean, that sometimes you are, and if we strip away all the nomenclature, all the language that we're saying, this is what we may be coming down to do. We are putting the nation on trial, but we are doing it within the confines of the process that has been created for that system. And the reason why state crimes may have been excised, they were like fleets of reasons that went before the state parties when this was being discussed prior to the articles coming out in 2001.
I just want to make sure I'm defining Article 19 for the for those who might not know. And please correct me if I'm wrong, but Article 19, which is no longer part of the draft, but it's part of the 2001 Responsibility of States for International Wrongful Acts, that was produced by the International Law Commission. And as you said, it listed a series of state crimes, which included things like genocide, but also included things like environmental harm. And that whole section was what was removed. Do I have that?
You have that, but the thing is, there is responsibility for international wrongs. And as you see, there's been a recent advisory requested from the International Court of Justice for Climate Change. We've seen the cases that have gone on for torture, for genocide right now before the International Court of Justice. So there is a framework, but it's just the way that you take the matter through the framework is different.
Okay. Sean, do you want to respond or do you want to move on to the second question?
Just briefly, I think Narissa and I are almost completely in agreement here. And just to make my position clear, I've argued against um, having state crimes. So I've argued that state responsibility should be purely reparative, and that the function of punishment should be confined to international criminal trials. So I'm a defender of the law in that way. Um, so in my view, there's a division of labor between state responsibility and international criminal law. So international criminal trials provide a mechanism for holding individuals responsible for the most serious international crimes, while state responsibility provides a mechanism for redressing large-scale collective or systemic wrongs. And these are not mutually exclusive. In some cases, we might want to put an individual on trial and hold a state responsible for the very same action. So, for instance, we could put a general or a president on trial for genocide, but at the same time demand compensation from the state that that president or general represents. And the reason that we'd want to do this is that individuals rarely have deep enough pockets to compensate for the large scale harms of a war or a genocide. And holding the state responsible also opens up the possibility of systemic reform or institutional reform as a response to wrongdoing. So I think Narissa and I are completely in agreement about what state responsibility
Absolutely,
should do.
absolutely, Sean. And what I would like to also say, and that is to pick up on something Sean just said. There's an author, an American author, Neha Jain, and she calls international criminals fungible intermediaries. And it's true, if you look at international crimes, if you cut off the head of one, another will grow back like a hydra, so they can keep replacing themselves. So that you may put the warlord before the court and we can address him as an individual. But as Sean was saying, with the state responsibility, we can now take a systemic look at that and snuff that thing out at the very root. Try to disable criminal systems, because with our approach to criminal law, it's prosecution and sanction, and you have an almost naive hope that, you know, if this person goes before the Hague, somebody else will see it and they'll never do it again. But state responsibility picks up where that falls short and says, no, let's try and get to the system so that we try and modify that. Now, I don't know if Sean would agree, is a lot of idealism, and the whole of international law is a lot of idealism, because in the bottom of our hearts, you do want a peaceful and better world. So you take the best minds to create these systems, but there will always be that factor. Is like we are working with, as Sean said in his book, the Leviathan. So how are we going to manage that, and how do the processes manage that? And I think this is a good year fit because we are seeing things being tested.
So I'm going to move on to our second question, and it ties in actually with an audience question. And if you, of course, want to respond, also you can do that, Sean. But Sean, is there another way to hold states accountable, or is this even necessary? Would it be better to hold individuals accountable, which is something you were talking about? And the question from the audience is, can Sean give an example of what state responsibility looks like versus individual responsibility?
Okay, for an example of state responsibility, I think a good one is the UN Compensation Commission that was set up in the aftermath of Iraq's war on Kuwait in 1990. So the UN Compensation Commission looked at the damages from this war and decided on a number that Iraq owes to the victims. And it was something in the range of 52 billion. So Iraq's oil revenues were garnished to pay the victims of this war. This is what state responsibility looks like in practice. This is a large-scale case of state responsibility, where the state harms either private individuals or another state, and where compensation is extracted from it. This is state responsibility in practice. International criminal law would look like putting someone like Saddam Hussein or Iraqi military officers on trial. That's a very different response. And both of these responses have their advantages and drawbacks. So the advantage of putting individuals on trial is that it provides an outlet for the inevitable demand for punishment or retribution in the aftermath of atrocity. Holding an abstraction responsible is just not psychologically satisfying in the same way as holding an individual perpetrator responsible. But as Narissa pointed out, holding individual perpetrators responsible often fails to address the systemic problems that led to the atrocity in the first place. On the other hand, holding states responsible provides a mechanism for large-scale restitution or reparation. It provides a big pot of money that can be drawn on by the victims. But in some cases, the burdens on the citizens of the state that's held responsible are enormous. So if you think about the case of Iraq, this 52 billion was an enormous burden on the citizens of Iraq. And many of these citizens were themselves victims of Saddam Hussein's regime. It's not quite clear whether this is a just response. So the benefit of state responsibility is that it provides a source of reparation. The drawback is that this can be a crushing burden, often on people who are by any standard innocent.
Narissa?
Yeah, so yeah, Sean. And you know what I'm thinking would be a really nice dramatic example that could bring it home to the person who asked the question. Let's look at the Ukraine and Russia. As you know, warrants have been taken out for President Putin before the International Criminal Court for international crimes there. And at the same time, Ukraine has instituted a separate matter before the International Court of Justice against Russia. So you are seeing it's basically the same things that we are looking, the same subject matter is being addressed, but we are addressing, excuse me, Putin as an individual where he will stand up for his own crimes if that warrant ever gets executed. And on a separate realm, you're looking at a matter where you are looking to see right now they addressed it through the lens of provisional measures before we go to the merits to look at other more long-lasting measures. Now, with the reparations, sometimes, for instance, Rwanda wanted a museum to commemorate the dead. It doesn't necessarily always have to translate into the form of compensation. Sometimes an apology, a declaration that I was wrong and I would never do it again, a guarantee of non-repetition may be enough to take that burden off the state, because what you are saying, Sean, is very correct. These people have already been brutalized by warfare and conflict. They can barely put one foot in front of the other. To saddle that now with compensation, where's that compensation going to come from? And that is where the nature of the remedies that are sought, the thoughtfulness of it, and international law is proceeding in that way, where you actually look at the nature of it and can this thing be addressed at that state level. So I think that might be a nice way of looking at it. Like you look at what has happened, and then you look at the pathways to responsibility, because these are very complex matters. And to just naively think that we could have one system to address it, it may not necessarily disable the wrong that is going on.
I agree. I think if we think of reparation too narrowly as financial compensation, we're bound to miss the point. We should think of reparation as repairing relationships. And if we think of it in those terms, then large-scale financial compensation is not always or obviously the best response.
Okay, okay. That's
I
all.
this is my own thought, which is I also think that this is a very interesting conversation to have when it's maybe not a war crime, when it is a climate change crime, or a climate crime. To your point, Sean, it might not just be we need to make, I mean, sometimes, yes, you have to provide a community with water or with maybe a place to go because their island is now underwater. There's a lot of different ways that reparations can take form, and I think it also depends on the crime that's being charged. And you're both welcome to disagree with me on that, if you would like to. Uh, what I'm gonna open this up to both of you, whoever can wants to start, but states are not the only legal fiction, so are corporations. So what about corporate liability in light of their positions on state responsibility? Are these parallel to each other, or is corporate liability distinct from state responsibility, even though the corporate actor is also technically a fiction?
I could jump in if that is okay, and then I will hand over the floor to Sean. So we're going to still stick with the regimes as they are. Now, if we are looking at state responsibility, that is the jurisdiction of the International Court of Justice. Corporations do not have a right of standing before that court. So it would be impossible to bring a case against the corporation. Now, a number of abuses have happened where states can actually be supporting a corporation. And this is my take on it. And if you could bear with me. So let's say we have the regime of state responsibility. As I said before, what is the primary thing in that legal process is that you are able to work out a chain of attribution of conduct of an individual to the state. Now, if a state has supported a corporate entity into the commission of an international wrong, but the level of support has passed the tests established in Nicaragua and Bosnia that it's either direction, control, or complete dependence, then that perhaps, this is arguable, that corporation is now a de facto state organ, and then that de facto state organ, you can put the state before the ICJ because it is responsible for the activities of that de facto organ. And to me, it will work akin to de facto responsibility for armed groups and so on, as happened in Nicaragua or in Serbia, where you saw people like the Red Berets, the White Scorpions, essentially doing work for the state and acting under state support. Now, in both those cases, the ICJ felt that the threshold of control was not strong enough. There was not complete direction and control. There was not effective control. These organs were not completely dependent on the state. So if we are looking at corporate responsibility through the lens of state responsibility, that is going to be a problem because states can support, but you are not responsible in law for support. You are only responsible in law for direction, control, complete dependence. So that is a possible lacuna there that will need to be addressed. However, countries like the United States of America, you have the Alien Tort Claims Act, and there may be other domestic jurisdictions with similar legislation that gives domestic courts the power to put corporations on trial. As of yet, we do not have that right of standing in the international legal systems, but you have to go about it in very roundabout ways. So this is the way that it can happen in terms of corporate accountability. I think it will be very important to address this area because I have a PhD student who has been doing some very brilliant work on this in terms of some of the abuses that she has been seeing at the hands of corporations within her home state. So there is a significant line of scholarship now that is trying to stimulate that gap and see creatively how this can happen in terms of addressing responsibility for these corporate entities.
Sean?
All right, let me cut the question the other way and consider what corporate criminal responsibility implies for state responsibility. I think there's a temptation to try to extrapolate or extend corporate criminal responsibility to the state. And I think the parallels here are interesting, but there are also some important disanalogies that we'd have to consider before we take this very far. So let me just mention a couple of them. The first is that while there are domestic courts that can put corporations on trial, there is currently no international court that has criminal jurisdiction over states. So the ICJ hears cases against states, but not criminal cases. And the ICC, the International Criminal Court, hears criminal cases, but not cases against states. So if we're going to put states on trial, literally, then what we need to do is create a new court, a new criminal court for states, or we need to reform one of the existing ones so that it can hear criminal cases against states. Another disanalogy, a more ethical one, is that corporations are voluntary associations, but states are not. So shareholders choose to join a corporation. So any costs or burdens they bear when punitive damages are levied against a corporation are ethically unproblematic. But most citizens don't choose to join their states, and they can't easily leave. So we should worry about imposing huge costs on people who are by all measures innocent. Punishing states, to put a fine point on it, carries a much greater risk of misdirected or unjustified harm than punishing corporations.
Can I ask, Sean, does your analysis change if the it's true that a corporation is a voluntary association in a place like the US or the UK, but of course, in history or in other countries, there's examples of more of a government private public partnership. From history, I'll just say the East India Trading Company, for example. Um, would this change your analysis?
Definitely, yes. What matters is that the organization is voluntary or involuntary. What we call it doesn't matter much. The East India Company was clearly involuntary if we consider the members of the corporation to be the people subject to its power. It's effectively like a state.
Narissa?
Well, so straight off the back, I cannot, I, I do not think that it is possible to hold a state responsible. Like we have the title nations on trial, but we cannot put a state on trial for a crime. It simply will not work as a matter of substantive law. There isn't that historical thing. But however, like I said, if we push back against the nomenclature and we actually look at what is happening, a state can be responsible for genocide. A state can be responsible for environmental disasters. And we can take a process where sensible requests on the claim for particular forms of remedy can be made. Now, the thing about the corporate liability is that, and this may go back historically, when we started to conceive of international law, it was just states. And that is why one of the primary questions they ask a first year law student is always, states are the paramount actors in international law because it is a state concept. And it is only after the end of the Second World War we saw the introduction of the individuals when we tried to address the horrors of the Holocaust via an international criminal system. But at that time, I wouldn't even call Nuremberg an international criminal system, but the actual trying to start prosecuting people for things that offended the conscience of humanity. There was never any real space dedicated sufficiently to naming a corporate entity as an actor in international law. And there are working groups now on the International Law Commission that are looking to that. And it is a topical question because, as I said before, you are seeing some of the horrors that happen from corporate actors. As I said before, I'm currently working with a PhD student that has called out something that when I read her work, these are crimes against humanity that has happened at the behest of particular corporations. So it is that space within international law that exists for actually identifying responsibility for corporate actors. Now, as lawyers, what you sometimes do is when you can't change the law, you start to look in different directions to see where there may be a solution. The solution may exist in domestic law, where domestic legal systems have created those mechanisms, such as the Alien Tort Claims Act. There would be limitations there, but the other way is probably to try to make some roundabout arguments, whether they are de facto state organs. These are not straightforward things that can be done. It will take a lot of work. Sean, I think they will never resurrect the idea of a state crime. I think states, to me, and this is personal, this has nothing to do with international law, I can see no state ever wanting to agree to something like that for fear of the backlash upon its own self. And therein is one of the problems as well, because states are controlling the law that they are making for themselves. So you have that human factor.
I'm going to move us along, unfortunately, because we're running out of time and we have some great questions.
Okay.
And so let me ask, what, very pointedly, what are some significant benefits of state responsibility and what are the drawbacks? Sean, should I start with you?
All right, let me just recapitulate what I've said before in a nutshell. So I think the most significant benefit of state responsibility is that it provides a source of compensation for large-scale harms, such as aggression and genocide. And states have deep pockets, as I said. The drawback is that holding states responsible can impose a significant burden on their citizens, who may have nothing to do with the wrongdoing.
Narissa, do you want to add to that?
Well, yeah, because I believe in state responsibility. I am a criminal lawyer in my heart, but when I saw all the things that you could do with state responsibility, I blossomed like a lily in spring. So I will say this, these are the benefits of state responsibility. And it's what Sean said at the beginning, and it's what I said at the beginning. We come back to it. It's systemic. You are addressing the problem at the very root. You are allowed to address the whole complex structure of an international wrong, and you are able to address it before it can go far. If the system works the way it should work, you can address it before it escalates. So that, for instance, we've seen several requests now to the International Court of Justice for provisional measures to control armies, to preserve evidence, to excuse me, to cease and desist from particular forms of behavior. So in the ideal world, and if this court was being obeyed, we can stymie the wrong before it perpetuates. You can have and the thing about provisional orders under the ICJ, there's no proof that all of the elements have been made up. You just have to, under the statute, prove that there is a plausible basis that this thing has happened. And you have now at your disposal amazing tools to protect societies. You can protect people by virtue of the orders that the court can make. That's the benefit. The drawback, enforcement. There is no police force, there is no compulsion other than the Security Council or the United Nations General Assembly, and I could talk about that a little bit later, that can actually enforce things. So that becomes a political question. This makes state responsibility the lion without the roar. It can do amazing things, but that is the drawback. How do you enforce these amazing things that it can do? And that is part of the benefit and the disadvantage of it. It can systemically address the international wrong. It can make wide-ranging orders. We don't have to wait for the crime to be perpetuated. We don't have to wait for the environment to be degraded. We can intervene on a provisional basis, but how can we compel the answers? And that becomes a political question, and we will need political mechanisms for that.
I have a very interesting question from the audience that I'm going to pose here, and it's to both of you. Can both of the speakers comment on whether the way the states are using the ICJ to address questions related to genocide to perhaps avoid using tools such as the universal jurisdiction or pursuing referrals at the ICC?
Well, it's parallel systems, so it's two different things. So there is nothing stopping a state from pursuing universal jurisdiction or using referrals to get things to the ICC. Remember, the jurisdiction of the ICJ is not looking at it as a crime. You're looking at the international wrong. So it's a different track of responsibility. And they are mutually supportive because, as I've said before, in the Bosnia and Serbia case in 2007, the court was able to request that people be surrendered to the ICTY. So I don't agree with that. I don't think so. I think you have to see the distinct systems. That's me.
Sean, do you want to add to that?
I think I'll pass on this one. I don't have a well-formed enough opinion to comment.
And just quickly, Narissa, this is also a question from the audience. Whether the state should be a signatory to any treaty agreement regarding the state responsibility to follow the rules as per international laws.
So the rules on state responsibility, like I said at the start of the talk, it is unique and it exists apart from the primary obligations. So states would sign on to treaty obligations for the states would sign on to treaties that give them primary obligations in terms of prevention or punishment of particular international crimes. But it's not only criminal, it could be any range of things relating to trade or the environment. So states would sign on to those treaties. And if there is a wrong, the system of state responsibility happens for itself because it has its own set rules, how to attribute conduct, how to organize reparations, and so on. So they don't specifically have to sign on for that.
Okay. And Sean, I'm going to turn to you with a thorny question that we came up with in our pre-chat. That could be a whole webinar in itself, but what happens when a state ceases to exist for state responsibility purposes?
I think the jury is largely out on this question, but let me just throw out a few examples for the audience to think about. The first one is the Armenian genocide. So the Armenian genocide was committed by the Ottoman Empire against the Armenian population, and then the Ottoman Empire ceased to exist. It was replaced by a bunch of successor states, including the Republic of Turkey. So there's a question now, over 100 years later, about whether the Republic of Turkey is responsible for the Armenian genocide. We can also ask about crimes committed by many other states that have either broken up or ceased to exist. We can ask about the Soviet Union and the Russian Federation. Is the Russian Federation the same state as the Soviet Union, or is it just one of many successor states to the Soviet Union? And this matters not just for responsibility, but for rights. There was a question after the Soviet Union broke up about what should happen to its permanent seat on the UN Security Council. There's also the case of the two Chinas, which happened in the aftermath of the Chinese Civil War. The government of China that was in place before the Civil War fled to Taiwan and set up shop there. It continued to exist. It even continued to keep the Chinese seat on the UN Security Council until the 1970s. Now we have the People's Republic of China, which has inherited that seat. There are all sorts of thorny issues that arise when states merge or divide or cease to exist. We can think of it maybe in terms of inheritance. Human beings cease to exist, and their estates can be inherited by their successors. Maybe this sort of law can give us some purchase on how to deal with these issues. But as you said, there's an entire webinar in this. I just wanted to throw out some things to think about.
Narissa, do you want to comment on that?
I think with any legal matter, you will always have to go through everything step by step. And in terms of succession, there are robust procedures in place that would identify the point at which you would have inherited the rights of your predecessor, or there may also be provisions in international law, for instance, if, let's say, you are an armed group, a revolutionary group, and you did heinous things while you were a revolutionary group, and then you now become the government. When you now become the government, then the acts of what you did when you were the revolutionary group are still acts of state, so you will have to answer for it. So like there's a way, there will always be ways of analyzing the link to the conduct. So like, for instance, let's say, let's use that same armed group. The armed group is a revolutionary group and they succeed in gaining power and overthrowing the current government that's there. Questions of responsibility would arise because you are now the state. So the state is indivisible. The state has continued. These are also points that, and that is the beauty of the work of the ICJ. They deal with these points either at the jurisdictional stage, and then once you've established jurisdiction, you move on to the merits. These are things that would have to be addressed as a substantive point of law, and there will always be arguments for and against on either side that will have to be weighted out in the wash.
Anything else to add, Sean?
Maybe I'll just add that these questions are often settled politically rather than legally right now. If you look at the case of the Russian Federation in the early aftermath of the fall of the Berlin Wall, the Russian Federation, along with a bunch of other post-Soviet republics, issued a statement that said the Soviet Union had ceased to exist. And once the Russian Federation realized the implication of that, which is that it wouldn't be entitled to the seat on the Security Council, the Russian Federation quickly backtracked and claimed to be the continuing state of the Soviet Union. So a lot of these claims of identity and non-identity, continuity and discontinuity, are made politically. And as it stands, it's difficult for the law to push back against these.
Before going to our final question, we do have one, I don't want to put you on the spot, but we do have one question from the audience that's asking if you have any comments on Ethiopia's government responsibility for gross human right violations allegedly committed in northern Ethiopia. I don't know if either one of you have read up on it, so if you don't want to answer, that's fine. But I just wanted to make sure that you have the opportunity if you can speak to it.
So whatever I would have read, it wouldn't be the exact evidence in front of me. I wouldn't know exactly. And I don't know if this might be the forum to comment on something like that. I would like to have more information in front of me. I would like to be able to say it in a more informed way.
Okay.
Yeah.
Sean?
I have nothing informed to say about it, I'm afraid. Must admit my ignorance.
And so we are at our last question and we have some time, so excellent. What big issues do you foresee for 2025 with state responsibility? Take out your crystal balls. Sean, should I start with you?
Sure. One emerging issue is how state responsibility will cope with new technologies and with increasingly complex institutions. So suppose that a state hires a private security company which uses an algorithm, which deploys a drone, which injures civilians. The chain of responsibility is becoming increasingly complex and difficult to disentangle. And this is not least because many AIs are opaque. It's difficult in retrospect to figure out how they've made a particular decision. So when you combine the issue that Narissa mentioned, that states act through corporations and have plausible deniability because of that, and combine that with the opacity of algorithms and AIs, and you combine that also with the fact that they're acting via robotic entities rather than human beings, it creates a series of conundrums for the law. So the big question, I think, is whether the international law of state responsibility will be able to adapt to new technologies and new institutional forms, or whether the law will need to bend in some ways, whether we will need to maybe rewrite some of these articles, which were written long before AI became a realistic possibility.
Narissa?
Well, I think the International Court of Justice has really come into its own since Gambia and the Myanmar case came before it in 2021. Right up to now, we are seeing a number of cases where states are actually going to the court to say cease, desist, assist. The challenge, I think, for international law for state responsibility in 2025 is enforcement. How do you make sure that orders are not just orders that are repeatedly ignored, but how can these orders be translated into some meaningful pathway for compliance or for just a peaceful world?
I'm going to give you each a minute or two to give some concluding thoughts. Maybe you didn't get a chance to respond earlier because I was moving us along too quickly. And I will start with you, Narissa.
Well, I think state responsibility is one of the things that I feel very passionately about because it is the identification of the ability of the international legal order to have a legal process in place to address wrongs even while they are ongoing and not to wait till their termination and then address it ex post facto. So it's the power of this mechanism to remedy and reparate in continue. Um, it's a wonderful topic, and if there are any students in the audience, it is an area that is still very much under researched, and there are plenty lacunas and blank holes in the legal framework. But I think as a common humanity, we can work together and keep filling those holes, and each generation just will be better than the next. And that is
Thank
the hope of it.
you. Sean?
I think I've said all I have to say about the specific questions. I'd just like to say thank you for the invitation. Thank you to Narissa for being a great interlocutor. And I've learned a lot.
It was amazing working with everybody, and I'm seeing the list of I'm seeing some really wonderful people in the audience. And for those I don't know, hello, and thank you, Denise, and thank you, Sean, and thank you, Tim. And I'm going to definitely go out and buy your book.
Yes, everybody should buy your book, both of yours. We have one last question. Do you want to get to it or shall I conclude? We got one last one. Can financial crimes be also covered under state responsibility if a particular corporation found guilty of the same is found to be working under the dire lions of political figures?
Okay, so if you can pass the attribution tests, if you can attribute the conduct of the individual to the state, yes. If you can't, it's a no, and you'll have to look for another regime of responsibility to address that.
Perfect. I want to thank you both. You have been amazing. And for those of in the audience, when we were doing our pre-chat, we already came up with 3 other webinar topics because they are so interesting and so well read and just fun to talk to. So thank you, Sean. Thank you, Narissa, for your time. Thank you for all the work that you do in this field and all the work you do outside of this field. And I want to also thank Tim and Regina behind the scenes. They make this super easy and do all the heavy lifting. So this is lovely. I just show up and have a engaging chat and then go on my day and they take care of the rest. So thank you so much. And thank you to the audience for all the great questions, for participating, for listening. And please stay tuned for the International Criminal Law Committee's next webinar in February on ICC sanctions. That should be exciting. And I wish you all a very happy rest of your day. Bye.